Good day, Dr. Hema. I'm Jaen. In these presentations, our group will evaluate the extent to which Malaysian laws on custody and guardianship align with the CRC standards. We will examine both the civil law and Sharia law positions and will propose relevant legal and policy reforms to address the existing issues. With the growing numbers of failed marriages, questions of custody and guardianship of children have become increasingly important. The United Nations Convention on the Rights of the Child is the most comprehensive international treaty on children's rights. Its purpose is to promote, protect, and ensure the rights and well-being of all children due to their age, vulnerability, and need for special safeguards. Malaysia acceded to the CRC in 1995. Although several reservations were entered, the country remains committed to upholding the rights of every child within its jurisdictions. However, Malaysia operates under a dual legal system, comprising both civil law and Sharia law. While both systems recognize the welfare of the child as paramount considerations, their approaches to custody and guardianship remain distinct. The governing civil laws on custody and guardianship in Malaysia are primarily the Law Reform Marriage and Divorce Act 1976 and the Guardianship of Infants Act 1961. These statutes outline the rights, responsibilities, and duties of parents and guardians in relation to children. However, neither provides a precise definition of custody. Instead, Section 89, subsection 1 of the LRA provides that a person who is granted custody of a child shall have the right to determine all matters relating to the upbringing and education of the child. Thus, it can be understood that the meaning of custody extends beyond mere care and control to include the right to determine the child's upbringing. While in Heward and Bryan, Lord Justice Sachs described that guardianship embraces a bundle of powers, which includes the power to control education, religion, and administrations of the infant's affairs. Therefore, it is apparent that Malaysian legislation does not clearly distinguish between the concept of custody and guardianship. As held in Kok Yong Hyong, the court cited the case of Helen Hall, where Justice Arulanano explains that the difference between custody, care, and control of the child was that care and control was a constituent element of custody and not synonymous with it. It means that while the two concepts often overlap, guardianship is only a facet of custody, which involves only the actual care, control, and access to the child. Next, I will discuss how the civil law provisions align with the articles of the CRC and identify any gaps of inconsistencies that may arise. Article 1 of the CRC defines a child as anyone under the age of 18 unless national law provides for an earlier age of majority. According to Section 2 of the Age of Majority Act 1971 and Section 2 of the Child Act 2001, a child is defined as a person under the age of 18, which are in line with Article 1. However, these definitions applies only in the absence of any definitions provided in other written laws, as the meaning of child may vary depending on the statute's particular purpose and context. The GIA does not expressly define child, but instead it defines infants under Section 2, subsection 1 as a person who has not attained the age of majority. Based on Section 2, subsection 2, subsection A, the age of majority is 18 for Muslim, while for non-Muslim it is 21. The GIA applies its provisions to infant, meaning person below the age of 21 in the case of non-Muslim, while other statutes such as the Child Act and the Age of Majority Act apply to child, meaning person below the age of 18. The inconsistency in domestic law creates legal confusion, as an individual may be regarded as a child under one statute but as an infant under another. While Article 1 of the CRC does not prevent state parties from extending protection beyond the age of 18, but for the purpose of the convention, a child is considered to be under 18. Therefore, the dual definitions in Malaysian law may lead to inconsistency in the applications of child rights protections. Article 12 provides that children who are capable of forming their own views must be allowed to express those views freely and must be given due weight in accordance with the child's age and maturity. Pursuant to Section 88, subsection 2, subsection B of the LRA, in determining custody, the paramount consideration shall be the welfare of the child, and subject to this, the court shall have regard to the child's wishes, where he or she is of an age to express an independent opinion. In Chang Ah Mei, Justice Lim Bang Chun affirmed that if a child is old enough to express own wishes, the court will take those wishes into considerations, not to give effect to them directly, but to better assess what is best for the child's welfare. As such, Section 88, subsection 2, subsection B expressly adopts the paramount considerations and requires the court to have regard to the wishes of the child, giving effect to both Article 3 and Article 12. The phrase, an age to express an individual opinion, reflect the CRC standards that the due worth is to be given in accordance with the age and maturity of the child.
Hi, I'm Ming Min. I will now discuss how the principle of the welfare of children under Malaysian civil law aligns with the best interest of the child standard under the CRC. Section 88 of the LRA states that when deciding custody, the paramount consideration in all cases is the welfare of the child. Also, the court may consider the wishes of the parents and the child. Similarly, under Section 11 of GIA, the court or judge, in exercising the power conferred by the Act, shall have regard primarily to the welfare of the infant and shall consider the wishes of such parents of the child. However, the parental rights are overridden if they are in conflict with the welfare of the children. In fact, in Malaysia's civil law practice, welfare is interpreted broadly and functionally equals to best interest. Hence, it can be concluded that these two provisions are aligned with Article 3 of CRC, where the best interest of children must be the primary concern in making decisions that may affect them. In short, in appointing a guardian of a child's property, the court may define, restrict, or extend the guardian's power and authority to such extent as is necessary for the welfare of the child. In J&C, the phrase of first and paramount consideration means that after weighing all relevant facts, relationships, risk, and parental wishes, the child's welfare is of highest priority in decision-making. While in defining welfare of the child, the case of L&S explained that it should be understood broadly, which is not limited to money or physical comfort, but also includes other factors. This approach closely aligns with the CRC Article 3, Paragraph 1, Best Interest of the Child principle, which requires a holistic child-centered assessment of all factors impacting a child's well-being. According to General Comments number 14, the concept of best interest is necessarily complex and context-specific, taking into account the child's individual circumstances, context, and needs. Similarly, the court's flexible approach in L&S considered more than material factor, which mirrors the child-centered interpretation. Moreover, the General Comment number 14 also warns the risk that best interests may be manipulated to serve adult interests, such as parental dispute, where the paramount welfare test in Section 88 LRA is sometimes inconsistently applied. Though L&S illustrates a positive judicial alignment with CRC standards, it also underscores the needs for greater conceptual clarity and safeguards to ensure that the best interest principle is not misused, but implemented through rigorous and right-based assessment. Therefore, LRA may be reformed by providing clear statutory guidance for the application of best interest of child, by inserting a structured best interest checklist within the provision, requiring the court to consider factors such as the child's physical, emotional, educational, and so on, considering non-discrimination and the needs for stability. Next, regarding application of GIA 1961 to illegitimate child in Malaysia. In Re Balasingham and Parawati, it was held that the Act is not applicable to illegitimate child, as the term infant should be interpreted to mean a legitimate infant, or the words father, mother, or infant in the Act do not naturally include illegitimate infant. In T&O, the court confirmed that under English common law, an illegitimate child's father has no legal rights over the child. In Yap, Lee Si, and William Tate and others, the High Court held that Peninsular Malaysia still applies English common law for custody of illegitimate children. Contrastly, In Sean O. Casey Patterson and Chan Hong Po, it was held that the GIA does apply to illegitimate child. Refer to Article 2 of CRC. It emphasizes equal rights for all children, regardless of birth status. In fact, the current provision of the GIA does not expressly define infant to include illegitimate children, which allows courts to adopt conflicting interpretations. To align with CRC, GIA should be amended to expressly state that it applies to all children, regardless of birth status. In short, guardianship rights and duties under Malaysian law should apply equally to all parents, whether the child is legitimate or illegitimate, to avoid discrimination of illegitimate children, which violates the CRC.
Good day, Dr. Hema. My name is Tan Hui Sin. CRC Article 5 emphasizes that parents, extended family, and legal guardians should provide appropriate direction and guidance to children in a manner consistent with their evolving capacities, thereby supporting the child's gradual exercise of rights. In contrast, Malaysian civil law on guardianship under the GIA and custody under Section 88 of the LRA largely reflects a more traditional, parent-led model of decision-making. Both statutes recognize parental responsibilities and enable courts to determine guardianship and custody in the child's welfare or best interest. They do not expressly incorporate the principle of evolving capacities. Guardianship decisions under GIA grant parents broad authority over the child's person or property, without requiring consideration of the child's growing autonomy. Similarly, in custody decisions under the LRA, although the child's wishes may be considered, there is no statutory obligation for parents or courts to adapt custody or guardianship arrangement to reflect the child's increasing maturity and ability to exercise rights independently. This creates a gap with Article 5, which envisions a more dynamic and participatory relationship between parent and guardian and child, one that evolves as the child matures. To fully align with CRC standards, Malaysian guardianship and custody law should be reformed to explicitly require consideration of the child's evolving capacities, thereby ensuring that parental guidance and court orders promote not only the child's welfare, but also their growing autonomy and rights. Article 18 of the CRC stipulates that both parents share common responsibilities for the upbringing and development of their child, and the best interest of the child must be their primary concern. Historically, under Malaysian civil law, fathers held superior guardianship rights over the infant under the GIA. However, following the 1999 amendment, Section 5 of the GIA now provides that both parents have the equal rights and authority over the infant. This development is aligned with Article 18, which promotes shared parental responsibility and equality. In addition, Section 88, Subsection 2A of the LRA allows the court to grant joint custody where appropriate, enabling the parents to share joint parental responsibility and care for the child. For example, in the case of Karen Chong Yuan Yi and Phua Cheng Chuan, the court allowed the application of the father for joint custody to ensure his continued participation in the decision-making concerning the children's education, health, and other matters related to their upbringing. Thus, both parents had equal rights for the care, responsibility, and to make decisions for the children's upbringing. Accordingly, both statutes reflect the obligations set out under Article 18 by promoting shared parental responsibility and prioritizing the best interests of the child. In Malaysia, the coordination and implementation of the CRC are primarily overseen by governmental bodies, supported by interagency collaboration, state-level mechanisms, and civil society input. The Ministry of Women, Family and Community Development MWFCD is the leading ministry in coordinating the child rights policies in line with the UNCRC. The Department of Social Welfare, DSW, is MWFCD's main implementing agency with regard to child rights and protection. In 2005, the Children's Division was set up by DSW to safeguard the welfare of children in Malaysia. Other than that, Malaysia enacted the Child Act 2001 to fulfill its obligation under the CRC. The Child Act is the country's legislation for the protection, care and rehabilitation of children. This act incorporates the core principles of non-discrimination, best interest of the child, the right to life, survival and development, as well as respect for the views of the child. This act has introduced several initiatives to safeguard children from violence, abuse, neglect, and exploitation. Moreover, incest has been criminalized by the Penal Code, while the Domestic Violence Act 1994 protects the child against violence within the family. To ensure better coordination on locally based service to families and children, Section 7 of the Child Act established child protection teams for the purpose of coordinating locally based service to families and children if children are or are suspected of being in need of protection. The child protection teams serve as a support system of child protection service and have the authority to call up from time to time such other persons as it may reasonably require to assist it in the performance of its function and duties or as the circumstances of each case may require.
Good morning. My name is Yang Jingwen. I will be explaining and analyzing the custody and guardianship under Sharia law. Under Islamic law, custody consists of hadana, meaning that nurturing and care, al-wilaya al-nas, meaning guardianship over the child's person, and al-wilaya al-mal, which is the guardianship over the children's property and finances. The responsibility of hadana, involving the care and upbringing of a child, primarily falls upon the mother. Literally, hadana means to clasp in someone's arm, to embrace or to hug someone, but it also means to nurse, to bring up, or to raise a child. Halafa interchangeably bear the meaning of hadana, which also provides similar definition, bringing up and looking after a child. Hadana also involves the act of caring for and looking after persons who are unable to care for themselves or distinguish between right or wrong, such as young children. The rationale behind this rule is that a children is considered incapable of looking themselves due to his mental development is still imperfect. In line with this, Islamic law views children as innocent during their childhood, as any harm they cause must be repaired by the guardian. This is supported by Hadith, which says that a recording pen is lifted in 3 cases: a boy till puberty, a sleeping person till he wakes up, and a mentally sick person till he recovers. Under Section 82A of the Islamic Family Law Act 1984, the necessary qualification to the custody is that they are Muslim. Whenever there are a dispute between a non-Muslim and a Muslim couple, the custody will always be awarded to the Muslim parents. This is a special status that was also stated under Article 3 of the Federal Constitution. This principle was further reinforced by Section 83D of the Islamic Family Law Act, which states that a person loses her right to the child custody if she renounces the religion of Islam. This requirement is founded on the belief that a person's religion reflects their good character. Hence, when assessing a child's well-being, Malaysian Sharia court placed a strong focus on religion and religious principle. In the case of Tunku Mahmud Shah, Nor Fadira Shatolan, the father obtained the custody for the 2 children, whose wife is a female converted to Islam and a citizen of the United States. However, she renounced the religion following the divorce. The father then argues that the mother is not eligible for the children's custody as she had remarried. The court granted the custody, care, and control of the both children to the paternal grandmother on the grounds of the children's welfare, particularly to ensure their continued religion upbringing in Islam. Subsection A to E of Section 82 provides the conditions of guardianship. Where a person shall be entitled to exercise the right of hadana, she must be a Muslim with sound mind at the age that qualifies her, is of good conduct from the standpoint of Islamic morality, and lives in the place where the child may not undergo any danger morally or physically. Decided cases suggested that good conduct means that a person is not fasik. In Khairul Huda Karo Abdullah and Shahruddin Haji Yassin, the custody of a son was then granted to the father's family, as the father was deemed unfit for the custody due to his lack of Islamic character, for he did not know how to perform his prayer, he consumed alcoholic drink that is forbidden in Islam. As the mother, someone who converted to Islam, was granted a temporary custody as she planned to return to her original country. The court felt that it was not a suitable environment for raising a child as a practicing Islam. In Rahanin bin Muhammad Yub and Adnan Ahmad, the mother's behavior was challenged on the ground that she did not perform her daily prayers and did not fast during Ramadan. However, these claims were proven baseless, and so she was granted the custody of the child. These cases further highlighted that good Islamic conduct is interwoven with the requirement of being a Muslim custodian to ensure the child's religion upbringing is properly maintained. Section 83 stated clearly that a woman may lose the right of hadana if she married with a person not related to the child by her gross and open immorality, by her changing her residence so as to prevent the father from exercising the necessary supervision over the child, abjurate of Islam, or neglect or cruelty to the child. According to Section 84, the right of hadana to the custody of a child will end when the child reaches the age of 7 for boy and 9 for girl. However, the court may, upon the application of the hadana, the custody of the child may extend it until the boy turns 9 and the girl turns 11. For al-wilaya, in the Islamic context, such as al-Zuhaili, define guardianship as a legal right or authority that enables a person to make decisions, enter into contracts, or manage property on behalf of an individual. This authority may be executed either with or without the individual's consent. From family law perspective, Muhammad Muhyiddin explains that a guardian, such as a father, has the power or the right to act in the best interest for those who is under his care and guardianship. The guardian holds the key responsibility for the children's overall welfare. Under Section 88 Sub 1 of the Islamic Family Law Act, stated that although the right of the hadana or the custody of the child may be vested in some other person, the father shall be the first and primary natural guardian of the person and the property of his minor child. Similar to custody, the guardianship will end once the child reaches puberty and demonstrates intellectual maturity, meaning that the child is able to think and act independently like an adult. In situation where no living parents, the guardian named in the will of the last surviving parent will be the guardian, providing this arrangement serve for the best interest of the child. In cases where no such guardian has been appointed, the orphan child can be brought before the High Court judge or judge in chambers to appoint a suitable guardian. Thank you. Next, I will be passing the presentation to Won Ting for the comparison with the United Nations Convention on the Right of the Child and the enforcement mechanism.
Thank you, Jingwen. My name is Chia Wan Ting. Following, me and Zixue will be presenting on how Malaysia's Sharia legal framework, the Islamic Family Law Act 1984 for custody and guardianship, aligns or conflict with the United Nations Convention on the Right of the Children, focusing on Article 1, 3, 12, and 18, and how the enforcement mechanism in Sharia court operates in actual as well as the reform needed. Let's start our comparison with the Article 1 of CRC, which defines a child as every human being below the age of 18 unless majority is attained earlier under national law. This provision mandates a universal protection for all persons under 18 regardless of gender, majority, or religious affiliations. The Islamic Family Law Act 1984, however, does not define child in the terms of a fixed age. Instead, it uses the terms of mumayyiz, which refers to a child of sufficient discretion. Section 84, subsection 1 asserted that it is when the child attains the age of 7 for boys and 9 years for girls. Under Section 81, subsection 1, custody hadhana is presumed to belong to the mother during the early years, but it is subjected to the opinion of the court under Hukum Syarat. Once the child reaches the age of discretion, mumayyiz, Section 85, allows the child to choose which parents to live with. However, even though the custody belongs to the mother, the guardianship remains default to the father as mandates in Section 88, subsection 2. This structure clearly diverges from the CRC's definitions, as it fragments the notion of childhood based on maturity and gender rather than a consistent age threshold. The reliance on religious maturity or puberty to define legal capacity undermines the CRC's foundation's principle of a equal protection for all individuals under 18, especially in matters as consequential as custody and guardianship. In order to bridge the inconsistency between the Islamic Family Law Act and the Article 1 of CRC, a statutory reform is necessary. The current concept of mumayyiz creates a fragmented protection for children. Therefore, lawmakers are urged to amend Section 84 and 85 to remove the age-based gender distinction. It is recommended to replace the differing age for mumayyiz with a unified approach where discretion is determined case by case by professionals rather than based solely on fixed gender presumptions. Following, Article 3 of the CRC demands that in all action concerning children, the best interest of the child shall be a primary consideration. Meanwhile, this principle was reflected in the Islamic Family Law Act 1984, Section 86, subsection 2, which mandates that in deciding whose custody a child to be placed, the paramount consideration shall be the welfare of the child. This provision seemingly aligned with Article 3 of CRC, which both recognize the welfare of the children as paramount and it includes the child's preferences. However, while the statute appeared to align, in practical applications, the best interest standard is not always consistently applied. When it comes to deciding the custody and guardianship right, Sharia court often apply presumption logic rather than conducting the best interest of the child assessment. It has been criticized that the Sharia court's narrow understanding of welfare is always reduced to just physical care and religious environment. This disparity is clearly illustrated in the case of Indira Gandhi and Ketua Polis Negara. A Muslim converted father obtained a Sharia custody order without involving the non-Muslim mother. Despite her having civil custody and the children has been living with her since the birth, the federal court later ruled in her favor and emphasized that the custody decision must involve both parents and prioritize the child's welfare. This case shows that even where welfare is supposedly the paramount under Section 86, subsection 2, the institutional practice may still be ignored and undermined by the Sharia court and judges, which could led to an outcome that is contradict to the CRC standards. To better protect the children's rights under Article 3 of CRC, Malaysian Sharia law must go beyond the declaratory language. Malaysian lawmaker should mirror Australia's model, where custody law includes a detailed statutory checklist to determine the best interests of the child and incorporate the best interest principle into the Islamic Family Law Act 1984. The best interest checklist will ensure that each custody case reflects the child's unique needs, wishes, and feelings rather than relying on generic presumptions. However, children's participation in Sharia proceedings remain very weak, with no formal welfare officers or interviews to capture their view. Therefore, Malaysia Sharia law must adopt a clear definition of best interest, mandate welfare assessment, and guarantee equal parental input alongside the child's voice. This reform will then align Sharia law with the CRC and better protect the children's rights and well-being in custody matters.
Thank you, Wan Ting. I'm Zishan. I will be presenting on Article 12 of the UNCRC, which emphasizes the child's right to freely express their view in all matters affecting them by ensuring that children who are capable of forming their own opinion are given the opportunity to be heard. I will compare the Article 12 with the relevant provision under the Islamic family law and propose possible reform to better align domestic law with international standards. Similarly, Section 86, subsection 2b of the Islamic family law requires Sharia court to consider the child's opinion is in custody once they can express an independent view. The Islamic Family Law Act also allowed children of Mumayyiz age to choose which parents to live with, as seen in the case of Mumuna binti Hamzah against Muhammad bin Ambong. Despite this provision, child participation in decision-making remained limited in Malaysia, with children often treated as passive rather than rights holder. There is no such procedural mechanism to ensure that the children are heard. In a Sharia court, there is no mandate for children interviews, legal counsel, or any sorts of welfare officer to facilitate their inputs or channel for them to express their views. Without a formal mechanism, it means that the children's voice are rarely considered in Sharia custody hearings, even when they are of Mumayyiz age. The court typically rely on parental testimony and assume that the child's best interest rather than seeking their input directly. In the case of Indira Gandhi, where the children were assigned custody without their view being heard at all, the court ultimately underscored the necessity of considering both parents and the children's view in family dispute in the Islamic context. In this situation, the children's participation is largely at the court discretion, which undermines the intention of Article 12 in the UNCRC. To better uphold Article 12, practical reform should include children interview procedure in Sharia courts conducted by trained psychologists or social workers to ensure the children's views are gathered fairly and without pressure. Second, mandatory social evaluation reports should be prepared by welfare officers in all custody cases involving children aged 7 and above. This report would assess the children's living conditions, emotional attachment to each parent, and overall well-being to assist the court in making child-focused decisions. In Malaysia Sharia court, sole custody is commonly granted to one parent after divorce, while other parents is allowed visitation rights under Section 87, subsection 2 of the Islamic Family Law Act. Overnight access is typically subject to a child age and court discretions. However, this approach appears to conflict with the UNCRC, particularly Article 3 and Article 18, which emphasize both parents share responsibility and the child's best interests. Sole custody leads to reduced parental involvement and neglect of joint responsibility. To address this, it is recommended that Islamic family law recognize joint custody as the automatic legal presumptions. The law should include the insertions of new chapters dealing with custody, child support, and visitations arrangements. However, any reform must ensure compatibility with the Islamic legal principles. In conclusion, while Malaysia has made effort to protect children's rights in custody and guardianship through laws such as the Law Reform Act 1976 and the Islamic Family Law Act 1984, there remains challenges in fully aligning with the principles of the UNCRC. To better uphold these UNCRC standards, reform should focus on improving procedures that allow children to have meaningful voice and promoting greater consistency between the civil and Sharia legal systems. Strengthening coordination and clarify with these frameworks will help Malaysia create a more comprehensive and child-focused approach, ultimately ensuring that the best interests and rights of every children are respected and protected. This is the end of our presentations. Thank you.